Subscribe, like, and share Cosmo Academia. Hey folks, John Oliver here, ready to unpack a topic more convoluted than trying to assemble IKEA furniture after a few beers. And trust me, I've been there. Today, we're diving into the fascinating and often misunderstood world of birthright citizenship. Birthright citizenship. Now, this little principle, also known as just soli, essentially means if you're born on U.S. soil, bam, you're a U.S. citizen. It's a concept that dates back to the 14th Amendment of the U.S. Constitution, ratified in 1868. This amendment was a monumental step in American history, aimed at granting citizenship to former slaves and ensuring that all people born in the United States are recognized as citizens. Simple, right? Of course not, this is America. We love overcomplicating things. The 14th Amendment's Citizenship Clause states, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." But as with many things in law, the devil is in the details. What does subject to the jurisdiction thereof mean? Who exactly qualifies? These questions have sparked debates and legal battles for over a century. See, most of the world functions on jus sanguinis, meaning citizenship is passed down through bloodlines like a family heirloom, but with fewer creepy uncles. Countries like Germany, Japan, and Italy primarily use this principle, which can make things tricky for people born abroad or to parents of different nationalities. Imagine trying to trace your lineage back several generations just to prove you belong somewhere. The US, however, with its melting pot aspirations, decided to throw open its doors. Well, not always open, but work with me here, and say, hey, if you're born here, you're one of us. This inclusive approach was meant to reflect the nation's values of equality and opportunity. It was a bold statement that anyone, regardless of their background, could become an American simply by being born on American soil. This simple concept, however, gets muddled by folks who think the US is like an exclusive club with a strict no new members policy. They argue that birthright citizenship encourages illegal immigration and anchor babies, a term that's as misleading as it is offensive. The reality is far more complex. Studies show that birthright citizenship has numerous benefits, including social stability and economic growth. It ensures that all children born in the US have the same rights and opportunities, fostering a more inclusive society. But here's the thing. Birthright citizenship is about as American as apple pie, baseball, and, well, arguing about who gets to be called American. It's a fundamental part of our national identity, reflecting the values of diversity and inclusion that have shaped this country. So the next time someone tries to tell you that birthright citizenship is a problem, remind them that it's been a cornerstone of American democracy for over 150 years. And like any good cornerstone, it's what helps hold the whole structure together. Subscribe, like, and share Cosmo Academia. Now let's talk about the 14th Amendment, the constitutional cornerstone of birthright citizenship. This amendment is one of the most significant changes to the U.S. Constitution, fundamentally altering the landscape of American civil rights and liberties. Passed in 1868, after a little kerfuffle called the Civil War, it was a time when the nation was grappling with the aftermath of a brutal conflict that had torn it apart. The Civil War was not just a battle over territory, but a profound struggle over the very soul of the nation, particularly the issue of slavery. This amendment was designed to ensure newly freed slaves were recognized as, actual human beings with rights. The Emancipation Proclamation had already declared slaves in Confederate states to be free, but the 14th Amendment was necessary to cement their status as citizens with full legal protections. The amendment's first line reads, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." This simple yet powerful statement laid the foundation for a more inclusive definition of American citizenship. Pretty straightforward, right? It seems like a clear-cut declaration that anyone born on U.S. soil is a citizen, regardless of their parents' nationality or status. Well, not if you're the kind of person who enjoys arguing semantics more than a family Thanksgiving dinner. The phrase "subject to the jurisdiction thereof" has been a point of contention for many years, leading to heated debates and legal challenges. See, some folks claim the "subject to the jurisdiction thereof" part excludes children of non-citizens. They argue that this clause was meant to prevent automatic citizenship for the children of foreign diplomats or enemy soldiers, but its application has been much broader. However, legal scholars, the folks who actually study this stuff, generally agree that the amendment was intended to grant citizenship to virtually everyone born on U.S. soil. This interpretation has been upheld by numerous court decisions over the years, reinforcing the principle of birthright citizenship. This amendment is a big deal. It has played a crucial role in shaping the nation's identity and ensuring that the United States remains a land of opportunity for people from all walks of life. It's the bedrock of equal protection under the law, a principle that has been invoked in countless legal battles to fight discrimination and promote justice. The 14th Amendment has been the foundation for landmark Supreme Court cases that have expanded civil rights, including Brown v. Board of Education, which ended racial segregation in public schools. A principle that, while not always perfectly applied, looking at history, remains a cornerstone of the American ideal. The journey towards equality has been long and arduous, with many setbacks along the way, but the 14th Amendment continues to serve as a beacon of hope and a reminder of the nation's commitment to justice and equality for all. Subscribe, like, and share Cosmo Academia. Fast forward to 2018 and enter Donald J. Trump, a man who loves executive orders more than a cat loves knocking things off shelves. Trump, with his characteristic flair for the dramatic, saw executive orders as his personal magic wand, a way to bypass the usual legislative hurdles and get things done his way. He wielded this power with gusto, signing orders on everything from immigration to environmental regulations, often with a flourish of his Sharpie and a grin for the cameras. See, executive orders are like presidential post-it notes, powerful but temporary. They can direct the actions of federal agencies and have the force of law, but they can also be easily overturned by the next president or challenged in court. It's a bit like writing a to-do list on a sticky note. It can be very effective in the short term, but it's not exactly a permanent solution. Trump decided to tackle the problem of birthright citizenship. This is the principle that anyone born on U.S. soil is automatically a citizen, a concept enshrined in the 14th Amendment of the Constitution. It's a cornerstone of American identity, but Trump saw it as a loophole that needed closing, particularly when it came to children born to undocumented immigrants. His solution? An executive order, because why bother with that pesky Congress and their whole checks and balances thing? In Trump's view, Congress was too slow, too divided, and too bogged down in partisan bickering to get anything done. So, he decided to take matters into his own hands, using his executive authority to try and reshape immigration policy. This executive order, as you can imagine, caused a bigger stir than a raccoon let loose in a library. People took to the streets in protest, legal scholars debated its constitutionality, and the media had a field day. It was a classic Trump move, bold, controversial, and guaranteed to grab headlines. It was immediately challenged in court, because even presidents have to, follow the law. The judiciary stepped in, with lawsuits filed almost as soon as the ink was dry on Trump's signature. Judges across the country issued rulings, some blocking the order, others allowing parts of it to proceed, creating a patchwork of legal battles that would take months, if not years, to resolve. The order itself, however, is a study in vagueness. It was filled with ambiguous language and left many details to be worked out later, a common tactic in Trump's executive orders. This vagueness made it difficult to implement and even harder to challenge in court, as lawyers and judges struggled to interpret what exactly the order was supposed to do. It doesn't outright end birthright citizenship because, well, it can't. The 14th Amendment is pretty clear on this point, and changing it would require a constitutional amendment, a process that is far more complex and difficult than issuing an executive order. Instead, the order aimed to reinterpret the amendment, a legal maneuver that was both bold and legally dubious. What it tries to do is exclude children of undocumented immigrants and those born to parents on non-immigrant visas from automatic citizenship. This would be a significant change, affecting thousands of families and potentially creating a new class of stateless children. The implications were enormous, and the backlash was swift and fierce. This, my friends, is like trying to put toothpaste back in the tube. Once citizenship is granted, it's incredibly difficult to take it away, and the legal and logistical challenges of implementing such a policy are immense. It's a messy, complicated process that is likely to create more problems than it solves. It's messy, illogical, and likely to end in a big ol' mess. The executive order, like many of Trump's policies, was more about making a statement than creating effective change. It was a way to signal to his base that he was taking action on immigration, even if the action itself was impractical and unlikely to succeed. In the end, it served as a reminder that while executive orders can be powerful tools, they are not a substitute for the hard work of legislating and building consensus. Subscribe, like, and share Cosmo Academia.